Hey everyone, Chad Tourin, back here with Barry Haimo. Hey Barry, how are you?
I'm doing all right. I got a haircut, so I look human again.
Looking sharp.
Doing pretty good.
All right. Barry, want to tell everyone a little bit about what we're going to be talking about today?
Yeah. So first, a little reminder intro for our new uh, viewers, visitors. My name is Barry Haimo Law. We've just been celebrating our 10th year in practice, which we're very excited about. We focus exclusively on estate planning and business planning, which deals a lot with wills and trusts, probate, business planning, asset protection planning, a lot of family work, and trust administration work. So it's a niche practice, but it's a big universe. Um, Chad, tell us a quick reminder.
We're Chad Tourin here with Coastal Wealth. What I do for my clients, both on the individual and on the business side, is help them grow their wealth in a tax efficient manner. Be cognizant of all the factors that can also deplete their wealth. And really finding that balance between the two. And on the business side, I really work a lot with clients, helping them grow their business, attract and retain good talent, and then ultimately figure out the best way for them to transition out of their business so that they do so on their own terms.
Okay, so today we're picking up where we left off. So last time we did the top 10 business, issues, business planning mistakes. It was just called Chad's top 10, and we basically added 8 more things to make it the top 18, which is fine. I enjoy talking about it. I think a couple of those items we're going to do dedicated breakout sessions after I wrap up on mine. And today, um, I have today's BH top 10 of what things can go wrong in the context of estate planning. Um, and I'll probably overlap a little bit with business planning. And I reserve the right to add more bullets as we go. And if it goes long, so be it. Um, so without further ado, why don't I read my little brief intro,
Sure.
and then if you want to, guide us through the process.
Absolutely.
All right, it works. All right. So, big picture here is that estate planning is a minefield for the unwary. I cannot stress enough how many issues that can arise that people just are not aware of. And thinking big picture, the consequences can be devastating in terms of money, in terms of family, um, and in terms of time. And so I'm hopeful that you'll take away some really good um, things today from our talk. There's an abundance of opportunities for problems to happen. We're going to try to give you some insight into how to avoid those problems, um, and hopefully you find us to be of value. And I think that Chad and I love this stuff. We like talking about this stuff, and hopefully that's conveyed, I guess, just through our just talking about it. So, with that being said, please.
All right. So Barry, we talked a lot about, you mentioned there's a lot of things that can go wrong if you don't do estate plan. So first, can you kind of tell everyone what would happen to their assets if they were to, not just their assets in terms of other things, things with children and things like that. What would happen if someone were to pass away without having done the proper estate plan?
All right, so I wanna break that up into, I think, number 1, 2, and 3, 4, 5. All of them really kind of touch on this actually, in
I
different
know it's a
ways.
broad one, as a broad question to start with, but I think without people understanding what probate is, and sorry if I stole your thunder there, but if they don't understand what that process looks like. I think it's a good starting point to break out into the smaller questions.
Well, let's back up. Let's zoom out just for a moment before you get granular on the probate. Just suffice it to just put in your mind, uh, a family with a business or not with a business, work their whole life to accumulate assets. You know, they're reasonably happy. They have a family, and then at some point, the inevitable happens, and they pass away, or they become incapacitated, which is not inevitable. Sometimes it happens. Um, that triggers a sequence of events that you either can control, or the government, the state, will control for you. Those decisions are out of your hands or they're in your hands, and you decide based on what you do now during life while you can do it. Um, just imagine what you want to have happen if you ever really sat down and talked about it. If Chad and I sat down and talked about our life and what we think for the future and our kids and our schools and a family, and God forbid something happened, what would we do? What would we think about? You would have probably a certain viewpoint, one way or another. Yeah, you might say, "I don't give a shit." That's possible. People do say that.
You get
But
that commonly on my side as well.
people say, "I don't care, I'll be dead." But they don't understand that really these things don't affect you, you're dead, or you're incapacitated. They affect the people who are surviving you, and just the trail of destruction that you leave them if you're just unaware of some of the problems that you're setting them up for, I think is not appreciated. And I think that it's a genuine gesture of responsibility, and love, and forethought to leave someone, you know, less of that type of problem with some planning so that they can transition and just really focus on grieving and not cleaning up a mess. And making sure things go the way you want. Because sometimes when things go the way you don't want, it's very sad. It's very disheartening to see that. So, all right. So with that very broad view, number one, you asked about probate.
Yeah.
So, in your experience, Chad, do you think people know what that is? Do
What were you to say?
you think people know what that is in your experience?
Unless they went to law school or had a family member pass away where they personally had to go through the probate process, very unlikely. So I think a great starting point would be to just
Yeah.
share with everyone what probate is. And then we can talk about, why it's important really you can talk about why it's important to
Yeah.
it.
Same with guardianship, I assume, right? Same it is. All right. So, starting with probate, what is probate, and why should you care? Um. So, if you pass away with assets in your name alone, it's very important. Assets in your name alone.
So not the joint bank account that you own with your wife, correct?
Right. Joint accounts with another person, which could be your wife, or um, other
Right.
accounts like retirement accounts that have beneficiary designations, or bank accounts that have like a TOD, POD, transfer on death, payable on death designation. They would most of the time bypass the court to get to where they need to go. For assets in your name alone, they're not going to bypass anything. They got to go through what I call the toll booth. I know you're going to steal this with your clients, and that's okay. But these assets have to go through the toll booth of probate. The toll booth. It's a great analogy because, like, how much of a pain in the ass is it when you don't have your Sun Pass and you got to go through the toll booth and stop, and you got to pay a fee? It's in the line. It's a pain in the butt. So probate is a toll booth.
Like the analogy.
It's a good one. I think you're going to use it. And so what that looks like is as follows. You know, you have to. We call it the ABCs, and it's a court process. It's in the circuit court of the county in which the person who passed away lived in upon the time of death. And you usually always have to have an attorney. So right away, you're looking at
Saying it's costly then.
yes, it's definitely costly. So you got to open up an estate um, for the person that's passed away, and we call that process kind of like the ABCs. You got to first have someone appointed as, in our state, we call it the personal representative. In other states like New York, where we're licensed and have an office, it's called an executor. Most people identify with the word executor, so I just use that. That's the person who, like the name suggests, has to execute on the will if there is one, or execute on the not will if there's not one.
Now, Barry, if the person passed away, who determines who the executor is?
Great question. If there's no will, or if there's a will and it appoints somebody who's disqualified, then the state has a statute for an order of priority. So like a spouse, family member, that kind of thing. It's a long, there's a bunch of people who would be appointed. There's a bunch of qualifications and disqualifications. And so there's someone has to be appointed, and that person's like the CEO of the estate. They're appointed with a fiduciary duty, which I can explain in a minute, to move that estate from start to finish. The ABCs comes into play because you have to identify the assets, the beneficiaries, and the creditors of the deceased. And all my subsequent bullet points, I think, are going to kind of talk about this in some way. So I'm really glad you brought that up. That was good. That was very, 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 very good. Very good of you. So assets, beneficiaries, creditors. Assets, jumping into number 4, it is difficult to figure out what people have, you know, uh, when they pass away. If you don't know, if you don't have a list, um, if you're not organized, that executor is going to have to run around.
Absolutely. And one of the things I try and do and help individuals ahead of time, and we call it the financial junk drawer. First step of any kind of meet with someone is let's organize your financial junk drawer so you know what you have, and more importantly, so your family will, or the person that you want to know what you have has somewhere organized where they
The
can.
junk drawer, you call it?
The financial junk drawer. Now, an analogy for you, maybe.
No, see, we have something similar, where we call it the snapshot. And, we've had to do it after the fact, like which we're telling you not to do now. And it's expensive. It takes a lot of time. You gotta, subpoena, you gotta mail, you gotta, hassle people to follow up with you to confirm if there's an account, if there's not an account there. And as an executor, you have a duty to be correct. So you can't just half-ass it. Okay. So you got to figure out the assets, house, cars, boats, bank, brokerage, annuities, life
I can
insurance.
imagine it could take a lot of bit of time since
Yeah.
people do have that duty.
Yeah, it takes time. People got to work. They're not just stopping their job to work on this full-time job. It's like a full-time job. Okay. So assets can be difficult, but also cannot be difficult if you're prepared. When you and I work together on clients, it's so much easier for us to deal with and help the client. But it isn't always that way. B is beneficiaries. If you have a will, you're choosing your beneficiaries unless screw it up. Do an online will or something like that, which usually has a million holes in it. In cases like Prince, beneficiaries is not so easy. Where people think they want to, people are claiming to be a beneficiary. They're claiming a blood relationship that has its own kind of legal process. But basically, you either decide or the state decides for you. There's something called the law of intestate succession or the law of intestacy, which is a fancy word for the judge, the stranger, will decide for you who your beneficiaries are.
Okay, what happens if, it really wasn't according? Well, if you're passed away, you wouldn't know it was according to your wishes. But what about the family members that maybe feel they're being bypassed and not, and things aren't going according to what the deceased individual would have wanted? Do they have any say if there was no beneficiary designations or proper planning done?
So you're saying, like, what happens if family is not happy with the decision?
The intestate, the order of
Oh,
intestate.
nothing. You're out of luck.
Right.
You're SOL. You either decide or the state decides for you. This is not a negotiation. This is not a marketplace. This is black and white. It's black and white. And that's, I think, on our list, actually, number 10 in terms of like challenging, the will. So we have your assets. You got to figure it out. Hopefully it's an easy process. Hopefully you're working with, an advisor and an attorney and a CPA together. By the way, Chad has a lot of alphabet soup after his name, and he has the CPA designation, the law degree, and the financial background, and I have a background in tax, computers, business, and law, so we make a good team.
They're a glutton for school, I guess you can say.
What's that?
We're a glutton for education.
Yep, we like punishment. So beneficiaries, can be easy. Nuclear families are easy, whether there's a will or not. Sometimes there's cases where that's not so easy. I've had cases where we've had to inject ourselves as a beneficiary and prove it, and then the case proceeds onward as normal. The creditors, I find to be the most common disruption. There's always creditors. Every person who calls me says they have a simple estate. It's always simple. It's never simple. There's always creditors. FP&L, Comcast, credit cards, mortgages, car loans, student loans. If you're a little bit older, the HCA for Medicaid or insurance, health, final expenses, funeral bills, whatever it is, there's something. And so the way this kind of process works, dealing with the ABCs, is that there's something called due process. You may have heard of it. It's kind of an important thing.
Quite a few times.
Due process. And so basically what that means in this context is that all these parties, these beneficiaries, the people who are not beneficiaries because you excluded them, the creditors or proposed creditors, they all have the right to notice of what's going on, and they have a right to cause a problem. And much like the presidential debate this week, probate, and I'm not going in political. I'm just saying that was a shit show. Much like that, probate provides a convenient venue for which I analogize as to a cage fight. Cage fight. It's a cage fight. It's like you're inviting problems, so people will be happy to cause a problem, and it has to be resolved for the creditors before the beneficiaries ever see a dime. Said
So there are
differently.
lots of creditors. I'd imagine this can get drawn out over a long period of
Oh
time.
yeah, oh yeah, oh yeah. Easily over a year. Easily. Um, I think new number 11 deals with one issue that I think will take it over a year easily. But I'm gonna make you wait. Not you, Chad, because you have access to the document, but with the user. Yeah, that can be very long. But the beneficiaries really have like equity in the estate. The creditors get paid first, the beneficiaries gets what's left. The only other thing I'll say about the probate process is, there's an order of operations. Everything's done by statute. There's certain order of creditors that get paid first, and then the general creditors, and then if there's anything left, the beneficiaries get it either by will or by statute. One more point that I get all the time is that a will does not avoid probate. A will does not avoid probate at all. It's a common misconception. So that's the toll booth of probate. It actually lasts longer than it took me to explain it, and it is expensive. It's time consuming. It's unpredictable, and it's really like you only want to do that in very few cases where it's beneficial, and mostly if you just don't like your family. So that's probate. Guardianship is like kind of the same thing, except it's for lifetime issues where you lack capacity. If you lack capacity, that means like you don't.
So to clarify for everyone, Barry, this is
Yeah,
not guardianship for children that you may be thinking of. This may be your own capacity that you're lacking.
So that's a good question because
I know
it's
guardianship.
actually both. It's actually both because technically minors don't have capacity. They don't have legal capacity. So like if you're inheriting, all right, this is a great question. It's a great question. So say you have a kid that's a minor that's inheriting over $15,000. You have to open up a guardianship. You have to open up a guardianship for that kid to be able for them to take possession of it legally.
I see this mistake all the time when it comes to life insurance beneficiaries, and one spouse will name their other as the primary spouse, and they try and name their minor kid as the contingent beneficiary. And obviously, children can't inherit large sums of money, let alone $15,000. So,
But the problem with that, I mean, it's not fatal that it's a little bit more of an administrative burden and cost to get that result. But what the real problem is that they do get the control of that money at an early age. So when they hit 21, they get control of that money. They can go to Vegas and they can roll it, go to the win and roll it all on black. So if you're okay with that, then fine, do that. So guardianship is yes for minor kids, but also for when someone lacks capacity, like Alzheimer's, dementia. They can't take care of themselves anymore. Someone has to be appointed as their guardian, and guess what? A circuit court judge will decide for you unless you decide for yourself. And that process is not quick and it's not painless. It's kind of public. It's a bit humiliating. And it's really to be avoided. I don't see any reason except again in very few circumstances to like intentionally go through a guardianship.
And not to backtrack, Barry, but going back to number one, in addition to costs and a lot of time, going into probate makes everything public, right? As well, or
Yeah, technically it's public record. I mean, it's not the easiest thing in the world to get to it, but yeah, it's public. So you don't if you want privacy, that alone should tip the scale in favor of maybe putting it into a trust, which is private. It's a good question. All right, so P and C. I'm sorry, P and G. Probate and guardianship. I think we covered briefly. You know, they're time consuming, expensive, and do you think it's important maybe to talk about how much money we're talking about here? You know, it's
I, I
relative
think
term.
so. And also because of the fact, you talked about things being drawn out over an extended period of time.
Yeah.
When your attorney there for over a year, I think you can elaborate more on what that might look like.
Yeah. So, um, there's a lot of ways that attorneys charge for probate. I would say there's maybe four types. There's hourly, fixed, percentage, or some combination of those three things. And we do all of them. It just depends on the circumstances. For example, you know, a $50,000 estate, we're not going to take a percentage. It's just not going to be worth it to us. Versus $100 million estate, we're probably also not going to take a percentage because that's not fair to the estate. So it just has to make sense. There's a lot of work. There's a lot of unpredictable things, but I would say a general rule of thumb is, 10,000, 10,000 plus, 20,000, depending on complexity, 50,000 if it's complex. If it gets litigated, ceiling, I mean, that's a lot of money. And all of that can be avoided. All of it can be avoided. So financially it's unpleasant, but also emotionally, psychologically, and familially. That's a word. Alright, so
Speaking of familiarity,
yeah.
could that, I imagine, could cause issues. Let's say if one um one child potentially has money and the other one doesn't, and they're contesting something in probate. I can imagine that could affect the outcome.
Only because I want to make sure we talk about it. I think that's kind of later, but let's talk about it.
Right? I mean, to jump ahead there.
No, it's fine. I mean, I don't know if we're gonna hit it because you know we enjoy this too much. Um, if you have a situation where someone is at all questionable in terms of their capacity, or someone has a close relationship with someone else and they're always together and that person just happens to be the beneficiary or disproportionate beneficiary. For example, and this happens all the time, but this is real. So you get older, you're in your 80s, you have health problems, you got 3 kids, the good, bad, and the medium kid. The good one, they're very good to you. They take care of you. They drive you to doctor's appointments. They're at home. They help you with your medication. They check in every day. They're involved in your life. The bad one, they don't give a shit about you. They can't wait for you to die. They just want your money. They don't call you, don't visit, nothing. And there's the medium one, which, is somewhere in between. And so you go to the attorney and you say, look, the good one, they're wonderful. They take care of me. I'm so grateful for that. I want them to have more. I want the medium one. There's still hope for them. I want the medium one to have some, and I want the bad one. I don't want them to get anything. And say that this person has medical issues. Say there's even a glimpse of lack of capacity. Say there's facts that support that the good one was, taking them to the attorney, involved in the process. All of a sudden you have now a very convenient opportunity for the bad kid to challenge the estate planning and say, wait a second, you didn't have capacity to do that. Or alternatively, you didn't know what you were doing. Good kid took advantage of you to get a better deal. You didn't really want to do that. They made you do it. This kind of scenario happens all the time. And unfortunately, there's a lot of lawyers that will take the case because that's kind of what they're supposed to do. They believe one side. There's always three sides to every story. So, and they'll paint a picture, and that case will probably settle in a way that would make the client, you know, absolutely livid. And it's very sad to see that happen. It happens. Um, and so we, as our firm, we kind of anticipate these types of problems. We really get to know the client, and we try to preempt those types of arguments by strengthening the file and, um, you know, just really strengthening the file to prevent and mitigate those types of contests. So we'll run more later, but it's
While we're on the topic,
yeah.
as a follow up, what are some things that you typically do to strengthen a file like that?
You're asking me for like our proprietary, you know, intellectual property here.
We'll save it for another time.
Let's just say, look, I once you kind of do it enough times and you see how they're going to be attacked, you know how to fortify what you're doing. You can't eliminate the possibility that someone's not going to hire a lawyer and
Right.
throw a couple Hail Marys. But you can maximize the likelihood that you'll succeed in your plan, and that's what we help people do. We don't guarantee anything, but we do our best to fortify and strengthen. And there's a lot of things it wouldn't make sense to talk about now.
Okay.
So that's number one: probate, guardianship, the court system, high level. Number two, um, I kind of think we talked about it already. Guardianship and advanced care directives. So a guardian is a person who's in charge of you. They can make decisions. They can sign contracts. They can control who you see. They can control which one of your three kids you see. It could be one of your three kids. It could be the bad kid in that example before. Imagine that. Imagine how the bad kid can turn into an angel all of a sudden in the courtroom, and they could be appointed because it's more convenient.
In terms of guardianship, at what point, because obviously if someone's incapacitated, let's say to the point that they're in a coma, clearly a guardian needs to, come in. But let's say the person is alive, they talk, maybe there's some issues. Who determines that the guardian is allowed to step in and start making decisions for that person?
So it's a process. You have to go and you have to do a petition. You have to be evaluated by multiple doctors, and then there's like a laundry list of powers and rights that you either keep or lose. And the guardian has the ones that you can't, the ones that you lose. And so at that point, once there's a guardianship appointed, there's a court order. And just like in probate, you waive the court order and, people listen because they have to. There's a legal obligation. This person has control. So in lieu of a guardian, and guardianship, does have its benefits in certain circumstances. But in lieu of a guardian, you can do your advanced care directives. You can do it a power of attorney, a healthcare surrogate, and a living will. And it's like a substitute. Just like a trust is a substitute for probate, advanced care directives are a substitute for guardianship. And so advanced care directives are very commonly, part of a basic estate plan. You see them all the time, right?
Yeah, you mentioned a few of them, and not only do I see them all the time, I encourage every one of my clients to get them. But you mentioned a few there, the power of attorney, living will, healthcare surrogate. Want to briefly touch upon what each of those are to kind of give everyone a little bit better understanding?
Yeah. So So power of attorney appoints a person called your agent. It used to be called an attorney in fact, but now it's called an agent. Either way, it's a person or a business, a company, professional, uh, to act on your behalf, as if they're you and for your benefit. They have a fiduciary duty. I mentioned that word before in the context of an executor or personal representative. That just means that they have an elevated standard of care to put your needs ahead of their own, or they can be held liable for either not doing that or being negligent, to not do that. It's a elevated standard of care. And so this person has power over things like financials, banking, insurance, legal, um, taxes. I always say Comcast in my meetings because I try to, lighten it up because it's a deep, dark subject. Nobody laughs at that though, so I really do appreciate that you're laughing. Try calling Comcast and seeing if they'll talk to you without validating them. Really getting, things done for someone else requires this type of document. Um, One judge who will remain nameless in Broward County referred to them as weapons of mass destruction because, as you can expect, going back to, good kid, bad kid, and medium kid, in the wrong hands, they could be quite devastating and destructive because third parties really do have to rely on them. They have to honor them. There's exceptions, but that's kind of the rule.
Can you
So
let's assume that someone has two good kids. Can they have
doesn't happen.
very true. But can they have and this is a question for the audience, can they have power of attorneys? Or does it have to be a decision on one of them?
Oh, that's a good question. So yeah, you can do co, you can do three, and it's majority. You can do co, and then they each have the ability to act independently by default. You can change that in the document if you want. I would say that, we give a lot of practical advice when it comes to these documents because some institutions are very fickle about how they interpret them and work with them. Um, it could be there could be problems with how people do it instinctively, and so we do provide some value there. But yeah, you can do that. The healthcare surrogate is like a medical power of attorney. It really allows you to participate and make decisions on behalf of someone else, um, as their surrogate. Typically it's for like, if you're unconscious, like you mentioned, you're unconscious and you can't communicate, you can't decide what treatment to take up in your case. Someone else is going to have to make the decision. And you can either decide, as I mentioned earlier, or the court will decide for you. In the case of a surrogate, the law changed relatively recently, and I think a favorable way, because it allows you now to appoint somebody who has the ability to participate now while you do have capacity, but you're still in control of yourself. You're still in control of your decisions. They can just be involved. I think that's very beneficial. And of course, they have access to
It
records.
depends like one for you then. For people that had healthcare surrogates created, for anyone who's listening who maybe has done some estate planning, do they need to get them amended to reflect the law change?
No, you don't have to. Just like a power of attorney and just like a will, wills that are outdated or from other states, you really don't have to get them done again, but you should because you should. I've seen a lot of problems probating out of state wills, even though they were valid, the courts still are a pain in the ass. Uh, the surrogate though does not need to be redone, but you should redo it because the laws change. So the living will doesn't appoint anybody, though I've seen them appoint people. Living will is think about Terry Shiloh in like the 90s. Her husband and family fought over whether to keep her on a machine because she was in a persistent vegetative state. For 4 years, they fought. God knows how much money they spent, but ultimately the husband, won, and they pulled the plug. She could have avoided all that with like a 2-page doc that said, "I do not want to be kept alive on a machine in the event of I'm in a persistent vegetative state, I have a terminal illness or end-stage condition, and and two doctors say that there's no reasonable likelihood of recovery. only then do they take you off the machine. It's not like you go and you're stubbing your toe, you know? So it's those 3 documents that are relatively simple, but significant impact in people's lives, during life. When you pass away, they immediately become, just useless pieces of paper.
Right.
Uh, so yeah, I answered that question pretty well, right? You're happy with that?
Absolutely. So let's go on to number three. We talked about how uncomfortable probate can be for the family. But let's say that even things are getting going through probate, um, and it's going by statute, meaning that the state's picking really who's going to receive what. We live in a society in a day and age where divorce is very common. People get remarried. All of a sudden, they have stepsons, stepdaughters. How does that affect the probate process, and or does it affect the probate process?
I was just laughing. I'm smiling because I was just thinking of like debates where they ask you a question and they just go and answer something that's completely unrelated to the question. Um, so to your question, which I'll answer. So statutes are really not that. It's not that complicated. It's black and white. Based on what the facts are, we could tell you what's going to happen every time. Okay, you don't have a will. Um, it's going to look to the statute, and it's going to usually go to spouse and minor kids to some degree, depending on whether the kids are a product of you and your spouse or not. And then if there's no spouse, no kids, it goes to like parents, and it goes to siblings, and it goes to grandparents, and it goes to like great uncles, and then it goes down. It goes down. It's like grandparents and then great uncles and cousins, and it goes kind of up and over. And ultimately, if you don't have any family, it will inevitably go to the state. But that takes time. And it's another common misconception that it goes to the state if you don't have a will, which is not the case. It will end up in the Department of Unclaimed Funds for a little while, and you can get it back from the Department of Unclaimed Funds. We do it all the time. But that's where it goes, and ultimately it will go to the state if unclaimed. So now you asked about blended families. That's what you were kind of alluding to blended families, right?
Right, because you mentioned it goes to the spouse and then the kids. Well, if you get remarried and now have new kids, or have a kid with that new wife, well, now maybe there could be some negative consequences potentially.
Yeah. So take a situation where you have husband has 6 kids, and with
Busy
wife,
man, busy man.
yeah, I don't know how to do that. I have 2, and it's a handful. The fact that it's quiet here is, it's a miracle. Say husband has 6 kids and wife has 3 kids. Okay. And say those 3 are from the husband. So in other words, husband has 3 kids from someone else, from either one or more people. If if depending on who passes away first, changes who gets what. Okay. So if wife passes away first, things go spouse and then 3 kids in some way like that, depending on if they're minors or not. If husband passes away first, then it's going to go spouse and 6 kids. So blended families is like rolling the dice. Uh, Depending on who goes first, depending on whether whose kids they are. A lot of times the blended families, you have these families where like they've been together a long time, and they treat the kids that are not really the biological kids as their kids, like they're my kids.
Right.
But legally they're not. Legally they get nothing. They're out in the cold. They get nothing. So if you want to change the statute, you have to plan ahead. There's nothing. It's just black and white. Okay.
Those
It's
guys
like
never control.
it's like in Florida. Like I've been married for 20 years, so I should get something, right? There's something called common law marriage. No, you're either married or you're not married in Florida. That's it. So black and white. Um,
Anything else in that area you want to touch upon in terms of the
Um,
and lack of planning, what that could do?
Lack of planning is such a broad.
Well, lack of planning for or lack of what happens when you go through probate with the inheritances.
I think for now we'll come back to it later if we think of something. So number 4, we kind of touched on when we were talking about the assets part, the assets in the probate, right? So you have. I like to use kind of these stories. You have this person with 3 kids, good, bad, and medium. Say this person passed away with $3 million, IRAs, 401ks, life insurance, all stuff that you manage, house, cars, bank accounts, brokerage accounts, um, some annuities, some CDs, CDs that are crushing it, paying like
They're
0.0002%,
doing awesome. They're doing awesome right now.
hideout for 5 years, those kinds of big winners. Um, say there's that kind of an array of assets. If you don't have a handle on it, and you and I aren't able to talk about it and kind of work through it quickly, like that's a process to figure out, to get these institutions to respond, give information. Once they confirm, get the court order, send them to them, have them send the paperwork to transfer it. You need to have someone like Chad, like you working on this together, or else it's a real pain in the butt, and it will be expensive.
You talked about assets and figuring out where they are, how much they're worth. You know, most really successful people, their largest asset is their business, and um, I'd imagine determining unless they're doing the proper planning all the way along, working with people like us, it might be pretty difficult for them to ascertain relatively quickly what the value of their business interest is worth. Have you encountered a lot of situations like that where someone passes away and they haven't done proper buy sell planning, which is something that I thoroughly enjoy and was one of my hot items on our last
Golden item.
video. So I know how to plan for that ahead of time. But how difficult it is it on the back end to ascertain the business interests and kind of divvy that up from an estate standpoint?
So jumping to number 11, which I'm going to bold because I get fired up talking about this issue that you bring up. First of all, I love business. Anything business, I love it. I want to talk about it all the time. So when it comes to businesses and estate planning, businesses and probate, it's an important point to talk about. So forgive me if I get a little excited. Um, when your business, when you pass away and you own a business in your name, if you don't have proper documents, your your management team has kind of just lost its leader. And legally, the personal representative, the executor, very well may be your successor. And that's not happening overnight. So you actually could have a disruption in your business until that does happen. And then, of course, your personal representative slash executor is now running your business, which may be a good idea and maybe a terrible idea, depending on.
I'd imagine most times they have no idea what the business is or how to run it.
Yeah, a lot of the times I would say in estate planning, when you have a married couple, it's the spouse. So think about whether you want your spouse managing your business. It's not about it's nothing, negative about the spouse. It's just that they're probably not involved, typically not involved, and typically they don't have the relationship with the other partners. And so there's like that disruption right there. You have a different legal manager now, and that's one issue. Another issue is that now you have an asset. So I deliberately skipped this one on my list of assets I mentioned earlier. But say in addition to all those other assets, you have a business. That business has a value, right?
Yep.
How do you determine value? Who determines value? The PR? The PR doesn't know anything about business. They don't know how to value it. They're not a professional, valuation company. So who does it in your experience?
I really, in my planning, it's not done on the back end. It's really done on the front end. It is some sort of professional who specializes in doing business valuations. There's quite a few methods that they can use. Um, but really it's important the same way to work with, uh, I guess maybe that can be part of the triumvirate, but really a subdivision of the triumvirate, really having a business valuation specialist for your business. It's important to have that updated as your business grows also. You don't want to have an outdated valuation on your business if you've increased substantially over the years.
Yes, let's talk about that. It's a great point. So take first, the first part is like the valuation. Like, what is the valuation? Then take the part about like what happens if your valuation, you did some planning, but it's wrong. So in the first case of dealing with valuation of business, like you mentioned, professional valuation companies exist. It's an art and a science. I'm fascinated by how they do it. It's not cheap. Well, of course, you're like, oh, it's expensive. I don't want to do it. We'll just go. What's a cheaper way to do it, right? We'll just go get a broker. The broker will tell us. Okay. Well, now you're in the cage fighting situation. You're in the arena. The cage match is in the arena of the cage match, and there's creditors and there's beneficiaries and there's people who have rights in the estate, and they don't like your valuation because that means they get less if it's a percentage, or they don't feel comfortable that your resources or your person you hired is qualified. So you're going to start getting multiple valuations, and you're going to be inevitably fighting over the valuation. And the judge, again, this recurring theme of this person, this judge stepping in to make decisions for you, now is telling you how much your business is worth. You know,
I'm sure he has tons of experience in valuing businesses.
yeah, right. And so you have this problem. I've seen it. I've seen it actually in a case of a beneficiary, the IRS as a creditor, and I guess another creditor trying to bring assets back from a fraudulent transfer, but all but complaining over the valuation that was done. And it was a lot of money spent on an estate that had very little real assets, real value. So that's issue number one. You're really putting your business in a blender if it goes through probate. Second issue you mentioned was, well, on your front end, you're doing valuation, and you're planning. So your business is great. You're starting out. You're doing well. You do $1 million valuation. So you do buy, sell life insurance funded. That way, if someone passes away, tell me if I'm saying this wrong, but someone passes away, the life insurance kicks in, buys out that deceased partner's interest. The surviving partners keep, that interest that was just purchased by way of the life insurance, and the company cruises along forward. That's how it works, right?
And the family gets what they're supposed to get.
Family gets a value that was, quote, the fair value of that deceased shareholder's share, right? Okay. What happens if before death the valuation is now 10 million and your buy sell is 1 million? What happens?
Issues.
A lot of problems. I mean, there's a lot of issues there, right? I mean, what do you do? The family is not going to be happy that there's $9 million they're not getting.
The remaining partners won't be happy either, because very likely that someone in that family is going to be part of the business.
Well, that aside, I mean, just if you have a buy sell that basically says that you have $1 million valuation, and you're not building into the framework the possibility that the business can be worth more later, please call Chad and me today, right now. Do not even listen to any more words and pick up the phone, because that's a disaster waiting to happen. So more likely than not, if you have a good business succession plan, you have good buy-sell planning, it will address the contingency where you have like a framework where there's insurance, it uses insurance. If there's a deficiency in the insurance coverage, it does it a different way, right?
Yep.
And so that way everybody gets the fair value. Now, again, it goes back to value though, right? And it goes back to value and fighting over value in the cage fighting match. So I think that addresses those two issues. You really got to plan ahead. You really have to be flexible and have a framework, and you really want to get it out of the court system so that you don't have disruption. The business is a big deal. We talked about it a lot, so I won't belabor the point. I will wait for your next cue.
Sure, sure. We've talked a lot about um, things that go into probate and ways to avoid it. And you mentioned there's lots of accounts with different beneficiary designations that would, um, you know, bypass probate. But what happens, in a scenario where beneficiary designations haven't been updated, or you got married and you never really thought to update your beneficiary
Right.
designation former spouse. How do the courts look at that, and what are some of the consequences in terms of taxation, and in terms of who may ultimately end up getting the money?
So a lot in there.
I think I'm seem to be very good at asking loaded questions for
Let's
you.
spaghetti you through with the ball there. Um, if you get divorced, the law does treat that person as being predeceased. Um, your settlement agreement and your final judgment incorporating your marital settlement agreement will have something to that effect as well. If you want to give your former spouse something again after you get divorced, that's fine. You're gonna have to do some planning though. Excuse me. For I would say one of the biggest things that gets me crazy, and I'm gonna bold it now, is not being attentive. It's not even about just not having a beneficiary designation on those accounts, but it's just not being attentive to them. So, for example, just to be clear, we're talking about assets that have a beneficiary designation. IRAs, traditional, Roth, SEP, doesn't matter. 401ks, 403bs, life insurance, annuities. Those are types of accounts where you can designate that someone is to inherit it by contract, by law, by contract. You show a death certificate, they start the paperwork.
Mhm.
There's no court, there's no toll booth. If you screw that up, you're going to have to go through the toll booth. You're going to go through probate. Now, there's two main problems with that. Two main problems with that. And this is like
That'd be
incredible.
not having batteries in your SunPass for those that have the old school ones.
This is like not having batteries in your sun passing a flat tire right before it goes out, fixing the tire, going into the toll booth. The toll booth person is leaving for the day, so they close up the booth. You got to now go in reverse and get in line. Like it's a disaster. So what happens is two main bad things. Number one, well, three things actually. Number one is that the person who you probably wanted it to go to is not going to get it, or they're going to get less. Okay. Secondly, it's going to go through the toll booth of probate, and that means it's now subject to the creditors. The ABCs, the C's creditors. If there's creditors, you're bringing an asset that previously was exempt from creditors is now on the table because it's a probate asset. It went from non-probate asset character to a probate asset, and now it's on the table to be taken away from the surprise beneficiaries. And third, and I think this is probably equally as important, if not more important than the second thing, is that you get an adverse taxation issue now. You well, the law previously, before the Secure Act, chime in here if I'm wrong. Prior to the Secure Act, spouses could roll it over for their lifetime, and non-spouse. No, I'm sorry. Spouses could roll it over Roth forever, right? And then non-Roth, regular traditionals, they could roll it over for their life expectancy. Because if you were to give an IRA to a 10-year-old, their RMDs, the required minimum distributions, would be much less than if the beneficiary was 84, thus allowing it to grow over time and be
Yes,
more
there
valuable.
is multiple beneficiaries, and one sibling was a lot older. That could be another issue because the younger one would be paying tax at the higher one's age.
That should be on here as another thing because when you do your trusts to kind of play that, games with that, you're right. The pooled trust with the elder Benny does trigger the RMDs are at that person's age, even as younger people. Trust for. I'm adding to the list. We're now at 13. So going back to the issue of pre-Secure Act, you could stretch it out. Post-Secure Act, I believe the spouse can still take over, roll it over. But the non-spouse beneficiary now has to max out by 10 years. They have to liquidate the whole thing and pay taxes on it at most in 10 years. And correct me if I'm wrong, but the RMDs are not actually spread over 10 years. The RMDs are actually life expectancy, whatever that is. But you got to liquidate at the end of 10 years to avoid penalties. Now, if it goes to the probate court, there's an accelerated liquidation date. And so now you got to take it out even sooner. And there's taxes. So this is a mistake. Don't make the mistake of thinking that everything is good. Check them often. We make sure that everybody, we work with the financial planners in what Chad calls the triumvirate. But actually we call it the trifecta. Either way, it's fine. We work with Chad to make sure that these things are right, because people make mistakes. We're human beings. And so those mistakes have consequences, and you just want to make sure that everything is the right way. So that's a good one. I get excited about that. Thanks for bringing that up.
Absolutely. I
What's
believe
next?
we spoke about the next one and difficult family dynamics. I don't know if there's anything you want to elaborate on that. But I think the biggest one really is when you have the good, the bad, and I guess the medium, as you say, and um, who's fighting for control of either finances or who's taking care of the parent. I think that's we talk about that fairly extensively.
We're in Florida. We're in South Florida. I want to add to that because it's down here. It's so prevalent. In your situation where you have good, bad, or medium, and medium's like playing politician, and sometimes they're on the fence in favor of good, and sometimes they're supporting bad. What the issue is that the elder parents are like political footballs. They're in the middle of a tug of war of control over the kids. Who has control of the money? Who's getting what? Who has control over visitation? Believe it or not, that's a big deal. Who has control over who the parent is seeing, spending time with? Because, one kid has the ability to influence the personality of the parent the more they're with them. This is where maybe guardianship could be beneficial, to have kind of a neutral person in the middle. Elder abuse doesn't just mean physical. Elder abuse could be emotional, psychological, financial, medical. I've seen some really disturbing things in my day, and I've only been practicing for 12 years, and I've seen some crazy shit. Quite frankly. So elder abuse is real. There's a new Florida
On the
statute
financial
on it.
side, there's special rules in terms of different vehicles that an elder may be going into. Even on the financial professional side, certain obligations that we have to abide by because there is elder abuse that goes on.
Yeah, there's a statute now on it that defines what it is and provides remedies for it. So it's really prevalent on here. It's very sad.
All right, so we'll move on to another one.
Yeah.
And especially here in Florida, it's a phrase that's passed around pretty commonly, and it's homestead. So I think first it'd be great if you can kind of let everyone know what homestead is, because everyone thinks it just always refers to the house and we pay less taxes, property taxes, because it came homestead. But I think there's a lot more to it, and so I think giving that basic understanding would be great.
Yeah, so I would say homestead is a monkey wrench in estate plans. I think there's a lot of attorneys that really don't fully understand how it works, and non-attorneys are really at a disadvantage as to some of these rules. So big picture, 3 things you gotta know about homestead. 3 things. Number 1, and this is probably already know this. Number 1, asset protection. Your house is sacred. It's your castle. Nobody's taking away from you. with few exceptions. Some of those exceptions are you don't pay your taxes, you remodel your kitchen, and then you try to rely on the asset protection benefits and say, I'm not going to pay you. That can result in what's called a construction lien, and they can definitely put a lien on your house and sell your house. But other than those exceptions, a few exceptions, nobody's taking your house away from you if it's homestead. And now it doesn't have to be filing anything to be homestead. It doesn't have to be declaring it homestead. If it's your primary residence with a couple of qualifications, it's your homestead and it's exempt from creditors. Number 2, there is that tax benefit that you mentioned. Tax benefit is you got to lean forward because your hair is disappearing.
I'll sink down.
And you have beautiful hair. You gotta let them see it. Number 2 is the tax benefits. It's real estate taxes. It manifests itself in 2 ways. Number 1, there's like a slight haircut on the value in which your property is appraised for real estate tax purposes. Yeah, there you go. So there's a slight haircut on the total value appraised and assessed. Number 2, your real estate taxes that are assessed each year cannot go up by a certain amount. They're capped. The millage rate is capped. So for an example, if you have a house that's like identical and you buy it today and the person next door has the same house and they bought it 30 years ago, your taxes are going to be based on today's value, which is presumably double the value of your neighbor. Your neighbor's taxes kind of inched along over that time. They might be double the value of the taxes. Same house, same value.
Typically gets that sticker shock after the first year.
Yeah, it's not pleasant. It's not pleasant. And so if it's not your primary residence, it's a rental property, you don't get that protection. And so your real estate taxes will probably go up every year substantially. Don't mess with Homestead though. It's a crime if you play games, and they can figure it out. They're smarter than you think. So don't play games. The third thing that is important to understand, I think, is the biggest in my world is the most commonly misunderstood, is the inheritance rules when it comes to homestead. Basically, the homestead is designed to stay in the family, whether you like it or not. If you're married and you have no minor kids, you can do a prenup or a postnup, and you can not give it to your spouse. But if you don't have a prenup or a postnup, you have no kids, your spouse is getting that property whether you like it or not. If you try to give it to someone else, so if I give it to Chad instead of my wife's still going to get it, but she's going to get it in a different way that I probably didn't think of, called a life estate. There's now new rules on making elections, but we're not going to get into that. Bottom line is that if you have a spouse and you have minor kids, they're going to get the house, whether you like it or not. And if you deviate from the rules, it's going to go to these people in some way with a life estate, or they can make an election. So there's a lot of limitations on what you can do with your planning, and you need to know the rules so you don't run afoul of them, which really will throw a monkey wrench in.
I think you got a good segue there, in terms of the spouse and maybe not the spouse not receiving the house. Obviously that refers to the house, but what happens, two people are married and one spouse tries to really disinherit the other spouse, not leave anything to her in terms of other financial assets. Is there any recourse for that surviving spouse, and how does that work?
So you're asking about disinheriting a spouse.
Yep.
If you want to disinherit a spouse in Florida, you have to move to Georgia. Georgia, I believe, is the only state where you can disinherit your spouse. Florida and New York, where again we have an office in Long Island, are states where your surviving spouse has a right to a minimum of the estate. The minimum in Florida is 30%. It's actually really interesting. It's called the elective estate. Elective. It makes sense. Your spouse has a right to elect to take what you gave her or him in your estate planning documents, or elect more if you were not very nice and gave him or her less. So say you give your spouse 50%, half. They're not going to elect 30%. At least I don't think they would. Maybe they would. Say you gave your spouse 5%. Well, maybe now they might
Line up
elect.
the right advisors, they wouldn't.
Yeah, like that's not smart. So they might elect to take more because they can. Now, what's interesting about it is that the elective estate, a lot of new rules on this. The elective estate is bigger than the probate estate. So probate's like, is it in your name or not? Black and white.
Bigger meaning more stuff can come into it.
Yeah, exactly. So the elective estate is like a laundry list, a long laundry list of things that are included in the elective estate. The first one's a probate estate. Then they add a bunch of things that are not probate assets, like certain kinds of life insurance, things that pass directly to the person outside of court actually come back in for purposes of computing the value that the surviving spouse is entitled to when they make an election. It's very interesting what's included, what's not included, how it works. There's very strict timelines on this, so you really got to be careful. But the point is that you brought it up. Surviving spouses have rights.
I brought it up because it's on the list.
Okay, don't take credit then. Don't take credit. So yeah, I think it's an interesting area. We get those questions a lot. So number 9.
One thing that everyone could probably see is that everything is really integrated. All this stuff really kind of works together.
Yeah, it's a lot of moving parts. I like to call it an Rubik's cube because when you're talking about like thoughtful estate planning, you're thinking of you know probate, tax, family law, inheritance law, asset protection, and guardianship, practicality. A lot of moving parts, and everybody has different goals, so it's a lot to think through. But bottom line is that failure to think through these things is going to result in surprises. Could be unpredictable, could be expensive, could be a lot of court, and there could be tax consequences, like you saw with the IRAs. If the exemption comes down, you could be paying 40%, 40% to the government above the threshold, which 20 years ago was $1 million.
Yep.
I mean, imagine that. So it's a lot to juggle. It's definitely a complicated area of the law. We don't recommend doing it yourself. Not for self-serving reasons, other than the fact that I get paid a lot of money to clean it up all the time, and it's very sad to see the families dealing with that. I would say the number 10 on our list, which was where we intended to stop.
And I was going to ask about that. We spent this whole time really talking about all the documents that you can put together and the planning you can do to avoid, negative outcomes. But even with these documents in place, what are ways that someone who maybe feels like for lack of better words, feels like they're getting screwed over? What are some things that they can do to challenge some of these predetermined outcomes?
I call them unhappy beneficiaries, not because like they're not happy in general, but they're dissatisfied with you know their inheritance. Um, well, if I assume there's estate plan documents. So there's like a will, there's a trust. Take for example, there's no trust, it's just a will.
Mhm.
There really is only a couple ways they could do that. I would say they can attack it uh, from from an angle of uh, lack of capacity. They didn't know what they were doing. They didn't understand the nature of their assets, who was going to get what. They just didn't know. In that context, that's a legal determination, not a medical one. Doctors don't like hearing that. It's actually not a medical determination. It's do you have the legal capacity? And when you have dementia and you have Alzheimer's, um, you have clear days, you have bad days, cloudy days, clear days, alternating, some worse than others. All that matters is that you're clear in the day that in the time that you sign those documents. That's why you're thinking, oh, well, that's so easy to do, but not when someone's making a challenge and they're bringing the medical records and they're showing that you were on medication, you were, the week ago you didn't know what your name was. Like those are bad facts, and so that's an invitation for somebody to argue you don't have capacity. So that's one angle is you lack capacity. Um, you should definitely be planning before that happens. The second way is you say, like, remember we talked about good, bad, and medium child. Someone really was controlling you, sort of telling you to do this, and you did it out of fear, or you did it out of, misplaced trust. You were compelled to do it. You were under duress. Uh, so challenging it under that angle, that argument, is like kind of like
Undue influence, right?
the ketchup in the hot dog. It's like you see both of them. You don't usually just see one of them. You see both of them all the time. The third way is to just, and this is, believe it or not, this happens all the time. The third way is to challenge them on the basis of they were not validly executed. They were not validly executed. There's all strict rules on how to do it. These online solutions, they don't do it for you. They disclaim. You sign away those liability issues.
Yeah.
And so a lot of times you have this person who they think they have a good document for 50 years, and then they pass away, not realizing, never really knowing just how vulnerable they were. And so a deposition can, I think, easily uncover the flaws in the execution. In COVID, you asked me about this earlier, off record, how we're doing it. How are we signing? How are we complying with the law? And we are doing it. We're doing it creatively. Also, I should mention, in Florida, I'm sure you're aware of this, Chad, but in July, just a couple months ago, it's October already. It's crazy.
I know, crazy.
It's been a long March. In July 1st, electronic execution of wills and trusts became acceptable. And it's not like a DocuSign now. It's not like you can just do the Zoom call and we can just take a doc and just sign it, and you saw me do it. And now it's actually quite challenging. We offer that service, except for wills. And the reason why we don't accept wills to do wills is because there's something called a qualified custodian that has to store them for like 100 years, and it's just not practical. It's easier to just get in the car and go see someone and do it. So e-signing is becoming a reality. I'm sure it's going to be litigated because there's a lot of holes in it, but challenging it, like I said, lack of capacity, undue influence, a flaw in an execution, and of course the e-signing routine. You're setting yourself up if you wait, or you have bad facts, and you have a beneficiary who's dissatisfied. There's an attorney who will take the case. If there's money in there, they will take the case, and they will make the argument, and they'll probably settle. So that's 10. So yeah, we strengthen documents. We try to help prevent that. And that's something that we uncover pretty quickly, I think. So I guess the next thing on the list is bold. We talked about it already. Business is going through probate. It's a no-no. It's a big no-no. You're going to waste a lot of money. You're going to disrupt your business flow. You're going to get the wrong people in control. You're going to have valuation issues that are going to be fought over by the various parties. I forgot to mention something in the last thing about challenging. You mentioned how do they know? How do they do it? So I mentioned the arguments of undue influence, lack of capacity, and valid execution. I forgot to mention, these people are generally, I forgot to mention two things. These people are generally required to get notice. That whole due process thing.
Yeah.
So you have to tell them. You have to say, here's the will that you got cut out of. Here you go. Go find your attorney. I'll hear from you in 20 days. So you have to tell them. But do you? Maybe not. If it's a will and it's in an estate, they have to get notice. If it's a trust, which is private, and if it's done right, it's executed before death. It's called an inter vivos trust. It's a lifetime trust. And you cut someone out, there's no notice requirement to give. There's no notice requirement to give notice to the person who's cut out in a trust, like there is in an estate. So that's one interesting thing about the notice.
Unless it's a surviving spouse, right?
Well, yeah, if you cut out your spouse and go back to the thing I just mentioned about the
How's that? Sorry, clarifying to everyone listening.
You go backwards. Yeah, so there's that, and there's also another interesting thing. If you do a trust, you're a young guy, you pass away in 70 years from now and you have a trust, every transaction that you've done during your lifetime after that trust was created, but before you pass away, is like reinforcing your capacity. It's reinforcing your intent. You're not just waiting until death in the death court, the toll booth, to challenge, your capacity, to challenge your influence and your intentions. Like, you've been doing that this whole time, and that's an important factor that I think is.
While we're talking about trust, something came to mind.
Yeah.
I saw this happen with a client. Let's say someone creates a trust, but they never actually transfer anything into the trust. What happens then in terms?
Happens all the time. A lot of attorneys, they just get, here's your docs, get the hell out of my office. They don't help you marshal assets over to the trust. Sometimes it's intentional and strategic. But basically, if you don't fund the trust, it's going to go through probate. And if usually you have what's called a pour-over will, where the will says everything that's in my name still,
Yeah.
send it over to the trust. So everything goes like this to the trust. Everything goes to the trust. But that happens in probate. So you're still going to do probate, but hopefully the pour-over will that says go to the trust. The worst thing you can have is you have this awesome trust, really well thought out, but nothing in it, and no pour-over will, no will, and you have an estate that goes this way, and a trust that goes this way that has nothing in it. I mean, that's kind of like the worst thing. So I wouldn't do that. Um, two more things, because I know you got to roll. Using trust on the retirement accounts as beneficiaries. I'm sure you see it a lot.
Yeah.
There's that rule you mentioned about the oldest beneficiary's life expectancy applying to the youngest. That's one issue. There's something called accumulation trust and see-through trusts to qualify for the tax rules. There's issues when it comes to charities being named. There's actually interesting issues with charities being named and whether or not you can timely get them the money. There's just a lot of things you got to think about when you do these types of planning. But trusts are used for retirement accounts, I think, primarily because of asset protection. Recent years, the asset protection benefits of inherited IRAs has been basically extinguished. There's no more protection. They're not exempt anymore when they're inherited. And so to protect them, you put them into a trust that becomes irrevocable upon death, and that's that protection. But you have to play by the rules, and most of the rules are tax rules.
Shed some light. That's news to me, so I'm glad.
Yeah.
I found value in our talk today. So
Hey, you learned something. It's a win. It's a win. All worth it now. The last thing I want to say is that, as Chad mentioned, as you mentioned,
not the triumvirate,
which I refer to as the trifecta, but we're talking about the same thing. You really are well served if you're working with, me, Chad, and a CPA on the same team at the same time, talking to each other about you and your family, your business, making sure you're moving forward in the right direction, sounding board of directors, whatever you want to call it. It's just malpractice for each of us to not be communicating with the others. It's impossible for us to do a good job for you without working together. So that I think you would agree, Chad, that it's a team sport.
I mean, you could tell this by our designations and our credentials. As a financial planner, I still like knowing the law and the CPA, and you're a lawyer, but yet have the LLM in tax, and we work with CPAs who are well versed in everything because we need to be able to speak to each other's languages and understand broader planning concepts, and then have each individual professional focus on what they do best, but everyone understands the broad picture.
Yeah, and in my experience, and you can tell me if it's different for you, when I bring you in, I'm kind of quarterbacking with the people I bring in to make sure everything's moving forward. And if you bring me in, you're kind of quarterbacking to make sure that I'm kind of working with you to make, it's just kind of how it works. And we make sure that we're working with the right people to, to make sure that you have the best planning possible. And there's always holes, there's always gonna be problems, but you're much more better served with the professionals on your team. Thank you very much for doing it.
Thank you. And
And
thanks everyone for listening in.
yes, thank you for listening in, and call us if you have any questions. If we can help you, we'd be glad to do it. And have a good rest of the day.
You too. Take care, Bray.
See you, bud.